So this is the second class of Section 6 in remedies, and we were talking about Ayoud versus Mobil Oil when we last met. And as I said to you at the close of that class, I think it's important for us to try and figure out when we read a case like Ayoud versus Mobil Oil is how do we make sure that we aren't used in a similar fashion as Ayoud's used his lawyer. And I'd like to believe that the lawyer wasn't complicit in that fraud upon the court by attaching the phony complaint. So I'm going to assume that the lawyer was duped. Obviously, it would be even worse if the lawyer was a willing participant and perpetrated the fraud as well. Obviously, that would mean that the Board of Bar Overseers would likely get involved. If after investigation that proves to be true, the lawyer would likely lose his ability to practice law. And I think it probably would be forever. I don't think it would simply be a suspension. So obviously, you never should, under any circumstances, assist with something like that. But even under the circumstances that we have to discuss that issue means that there will be times where your efforts to root out that type of abuse or fraud, even vis-a-vis your own client and what they provide you and the information they give you, it's important so that your reputation and your advocacy on behalf of the client isn't affected because that you have been put in a defensive position and your client has likely lost his case as a result of it. Because that's the thing is if you look at Ayoud, once that fraud is discovered, during discovery that the plaintiff has falsified evidence, provided them to the court in an effort to try and gain their sympathy, that you know that this case is over for the plaintiff and the rest of it is just a reason to find against him. And when we do look at the case, we're going to see that there's an awful lot of errors that are made along the way, but no one cares, not the trial court, not the appellate court, because you've got an unsympathetic client. And not just unsympathetic, but you've got a fraudster for a client who has come to court with unclean hands, who has not done equity. The old axiom is one who seeks equity must do equity, and in fact has come to court with very unclean hands. And at this point, his case is over. So what do we do? I mean, what do we do? With respect to preliminary injunctions, there's always some urgency to the situation. Client always wants to go to court yesterday. But if you don't slow the whole process down and really recognize that Rule 11 doesn't take a holiday when clients are saying that they've got an emergency, because most of them do, but that especially in situations where you think you need to move with some dispatch, it's even more important to recognize that Rule 11 requires you to thoroughly, factually, and legally investigate the matter. And so when you look at a case like this, hopefully it awakens you to the types of problems that you will encounter in practice, but it also raises the delicate issue of how do you, in essence, challenge your client's trustworthiness and the information and the documents they provide you in a fashion that they recognize that what you're trying to do is help them put forward the best case. And it's not that you necessarily don't believe them, but even if they're telling 100% of the truth, the fact is if they don't have factual support by way of documentary evidence or other witnesses who can confirm what they're telling you, then at the end of the day it becomes a he said, she said, which is a much harder case to win at any rate. So as you think about this, well, what could he have done here? I mean, should the lawyer have talked to Monahan, in essence, the adversary with that purchase and sale, to flesh this out a little further? I guess one thing you could have asked to see is the payments for the purchase, if in fact payments have been made. The banking information, what support you have for the data that you've given me. And that's again can be readily explained to the client, is that we're looking to have the strongest case possible if we're going to seek injunctive relief. I don't think it's something you can't do with a client. I think it's something you must do, and I think there's a way to do it so that they recognize that what you're doing is try to advance their best interest in the most likely successful case with the best supporting evidence. And I think if you framed it properly, there's no reason why a client shouldn't go out of their way to try and gather the supporting information. And to the extent that they are resisting providing any support for the information, well, then that should ring off alarm bells and red flags. And even if they become indignant that you would question some of this, again, that's a flag that something just isn't quite right. What I know after practicing law for a long period of time, is that you can't take anyone's word at its face value. What you need to do, even assuming you believe it completely, is to see what support exists for that, because at the end of the day, when we go to court, we need to produce the proof, and the stronger our case is with the more supporting proof we have, the more likely we are to be successful. So I think my caution here is, don't just repeat the flowery words. Oh, a lawyer has to do a good investigation, factually and legally. Think about a case like this. Well, what would I want? I mean, one thing when I look at something like this is, well, I'd want to see the checks. I might have wanted to talk to Monahan to get some support for approvals, or what his interaction with Mobile would have been. I would have wanted to speak with him directly. If he's supportive, then I would have obtained an affidavit. If he was squeamish about providing an affidavit that I could use for a preliminary injunction, that would again give me some cause to rethink whether this is a case that we're going to run 100 miles an hour at, and find out that we're standing out there naked with no support. So again, think through it from a standpoint of, okay, in the real world, I know all the flowery language under Rule 11, and that the various professors have preached to you over the years. What does that mean? What would I have done differently here? What should I have done differently to avoid damage to my reputation and my good name? Because you start out with no reputation, but it'll quickly either go up or down depending on how you ultimately practice law. And this is a serious problem that happens in this case. And I'd like to tell you it's very rare, but it isn't, because we have an obligation to make sure that we have thoroughly, factually, and legally investigated the matter, and not just said we've done it, but actually do it, so that we can document to others what we've done when it's questioned that we have been less than forthcoming with the court, or we have violated Rule 11. So let's look at the case specifically. We've got these cross actions now, both seeking preliminary injunction, AU to prevent Mobile from terminating the new franchise relationship from the station he bought from Monahan, and Mobile to say, you guys, you need to get out. You don't have a right to be there. We never approved this sale. We're rescinding the franchise. You're out, because we don't want more than one person to own more. No person can own more than one franchise. So then the court talks about the 5-part test. Is there an adequate remedy at law? Will money damages make the plaintiff whole? What's the likelihood of success on the merits of the matter? The potentiality for irreparable injury, immediate irreparable injury, I like to look at it as. Then you have to balance the relevant equities, it says. And that's the balance of harms. No matter what, there are competing harms here, if you believe the versions of the events of both Aoud and Mobile. And so that has to be balanced. What if I do grant the injunction? What if I don't? Where do the requisite equities lie on a case like this. And then the last part of the test is what, if any, effect this might have on the public interest. As they go through that analysis, the trial court feels that, as we've said from the outset, the plaintiff isn't going to be successful here. But the plaintiff is not done making misrepresentations to the court and damaging theirs and yours, whoever the trial lawyer is, their reputation. One thing they say right from the outset says, plaintiff tries to convince us that Massachusetts law does not allow courts to enjoin a trespass. That's just a complete misstatement of the law, and that's what this says. In fact, later on in the semester, we're going to look at trespass actions and nuisance actions, and we're going to see that there is no doubt, as this court says as well, that Massachusetts will in fact enjoin a trespass, and it's not unusual at all that if you've got a continuing trespass to real property, such as existed in this case, that the court can and oftentimes will enjoin that party that is committing the trespass. So again, I don't sort of understand it, but I guess if you're in for a penny, in for a pound, you've committed fraud upon the court. Now you're misrepresenting the law to the court, and not, marginally. This isn't a gray area. You're going out of your way to misrepresent long-standing Massachusetts law. It makes no sense whatsoever, and making such a silly argument makes me wonder whether, in fact, you may have been, whoever the lawyer is, may have been complicit in the fraud as well. The status quo is the next question that the court starts to look at. A lot of times with injunctive relief, parties seek preliminary injunctions in order to do what we call preserve the status quo. And what preserve the status quo means is put them back in the position they would have been before all this controversy arose. Status quo is not the last point before litigation began, as one might think. The status quo is, where were they before the controversy developed? And if you think about it from this standpoint, well, where they were is Monahan had his station, Ayoud has his, and Ayoud was not running the second station. It is oftentimes a relatively easy sell when seeking a preliminary injunction to ask that the court to preserve the status quo. But the status quo is the last uncontested status which preceded the pending controversy. That would, if the court issued an injunction to preserve the status quo, what that would mean is that Ayoud cannot operate the second section. Then Ayoud wants to argue, well, Mobil waived this provision about not operating a second station. As it says, under Massachusetts law, you need a clear, decisive, and unequivocal conduct on the part of the defendant's authorized representative in order to have a waiver. Here, obviously, the contract indicated the waiver should be in writing. There was no proof to that standard, clear, decisive, and unequivocal conduct, such that you can argue the waiver, especially now where Ayoud's credibility is seriously in doubt. The fact is, he would have had difficulty proving it if he was trustworthy. He's got a virtually impossible task now. And then there are procedural flaws, and significant procedural flaws, frankly, with the manner in which this preliminary injunction was allowed against Ayoud. We've said before, there's a question about a hearing, there's findings of fact that should be issued, and then there's a bond. Now, we've already seen that a hearing isn't necessarily a prerequisite unless there is a sharp factual dispute, such as that the credibility of the witnesses is key. Now, the court says here, as a general rule, where issues of fact are disputed, an evidentiary hearing is a highly desirable prelude, if not necessarily concomitant, to the granting of an interlocutory injunction. While it isn't indispensable, when you've got that sharp factual dispute, in the First Circuit, where we are, there should be an evidentiary hearing. Under the circumstances, again, because you don't have a sympathetic plaintiff, they don't care. We heard it on the written submissions. We heard them at oral argument. We don't care that there was no hearing, because we don't care for the plaintiff. The other procedural part of the challenges here are that there should have been findings of fact and rulings of law under Rule 52. We talked about this, that the rule specifically requires findings of fact and rulings of law, and almost invariably, if they were not done, it would be returned and overturned because it's an error. As said before, the findings of fact and conclusions of law can be oral. They can be read into the record by the trial court, but they must be done. Here they were not. Again, this case reinforces the notion that it could be done orally. Here, the court didn't make findings of fact and rulings of law until 2 months after the injunction was issued. That, as the court says, it's just too late under those circumstances, and it's too long considering the circumstances here. But then they excuse that error as well by Judge Nelson, again, because you have an unsympathetic plaintiff. I do not think that that error would generally be excused. And then lastly, the issue about, well, where is the bond that should have been issued? And here they put it back on the plaintiff, saying, well, you didn't ask for it. You don't ask for it, you can't expect the court necessarily to grant it. Since you didn't ask for it, you're out. And so, again, there's a lot of procedural errors here. The problem is no one cares because your client, you, the plaintiff in this matter, has attempted to commit a fraud upon the court, and they're not going to allow him to benefit from that attempted fraud. I think it's a good case, and I hope you take a careful look and think about the issues raised, because the key issue here really is the failure of the lawyer to properly investigate fully, not just the facts and circumstances, but the evidence that supports it, to really roll up your sleeves and make that investigation, and not just put it to the flowery language, but actually get a little dirty in trying to make sure that there's ample support for it. Even with all of that, sometimes you're going to be schnookered. But to the extent then you can document what you've done and you can explain how you got to where you're at, that likely will be able to, at the minimum, lessen any type of punishment that you would otherwise get. But more importantly, I think it allows you to sleep a little more soundly at night, knowing you've done your job. And obviously, once you've discovered your client is of this sort, then never represent them again. And hopefully, if you can withdraw from the case without further damage to yourself, you should immediately, because you are at some point measured, at least in part, by the clients that you represent. And so lastly, by the way, here on the bond, if you look at the last note on 8, that ultimately, after the case was in the appeals court, the judge set the bond at $60,000. Mobil immediately posted it because that's nothing to them, and they knew it was error not to require a bond to be posted. So they were trying to paper over the errors at this point, with the expectation that the appeals court then would excuse the judge's various errors in issuing the preliminary injunction, because Mobil's hands are clean here and the plaintiff's hands are not. Let's talk a little bit about Doctors Associates versus Stewart. And this is another request for injunctive relief. And what's interesting about the request here, and then we see this as more and more common these days, is that there is a compelled arbitration provision within the franchise agreement. And so the question is, well, when we have such a clause, are we able to seek preliminary injunction from the court, even though there is a required arbitration clause within the agreement? And is silent with respect to where you can go for this injunctive relief. So what happened here is Doctors Associates sought to compel the defendant, their defendant at that point, to go through with the arbitration provision that's part of the franchise agreement. And so where the plaintiff had wanted to go to court and try to litigate the matter there, Doctors Associates instead wanted to compel the arbitration and to prevent the plaintiff from moving in any other forum with their case. So we've got dueling pieces of litigation, one in Illinois and one in Connecticut, trying to gain the high ground here. Again, not uncommon in commercial litigation at all, that each is trying to gain the home court advantage, and the best defense is a good offense, so you try to get to court faster than the other guy. And there's all sorts of clauses here about problems with respect to jurisdiction and all the rest of it. And so there's some interesting issues about, can you contractually agree to waive personal jurisdiction or agree in a forum, and the answer is absolutely. And there's some arguments here about fraudulent inducement and the like, and it tells us what the essential elements of an action in fraud are. False representation made as a statement of fact, knowing that it was untrue, that it was made to induce the other party to act on it, and that the other party did in fact act on it to their detriment. So what we've got are two parties who both feel wronged and trying to avoid the arbitration provision, at least by the franchisee. And so the question becomes, what are we going to do with respect to both the hearing issue, the jury trial demand, because the defendant would like, not the defendant, I should say, it is the defendant, but it's the franchisee wants a jury trial on the arbitration defenses of fraud and waiver. But the fact is, as the court says, you can't simply resist the arbitration provision you agreed to by now claiming a jury trial and thinking that that demand will allow you to escape what may have been a very bad business decision, but you made that business decision, and these arbitration provisions often are enforced because parties can contract away their rights if that's what they choose to. The law supports that, but also as a practical matter, this means generally didn't hear, but should mean less work for the court to do if in fact you have to pursue whatever grievances you have in a compelled arbitration. There was no bond posted here, and so obviously that's another question of, well, what happens with the bond? If there was no bond, isn't that an error, as we've seen under Rule 65C, because Rule 65C talks about the requirement of a bond. And what this case says, and now this is the Second Circuit, so we get a little variation from the First Circuit, and we would see, as if we go to different federal circuits across the country, that there'd be some variation here. But what this says is that the district court is vested with wide discretion in the matter of security, and it has been held proper for the court to require no bond, where there has been no proof of likelihood of harm, or where the injunctive order was issued to aid and preserve the court's jurisdiction over the subject matter involved. In essence, to require them to go forward with their arbitration as they agreed to, or where the non-moving party hasn't shown any damage they would suffer in monetary terms as a result of the injunction issuing. Remember, the whole idea about the bond is that it's there for damages to the non-moving party if it's later determined that the injunction was improvidently granted. In the event you can't make that proof that you are going to suffer damages and what they are likely to be at the preliminary injunction hearing, or you don't request it, as we saw in the last case, then you can't complain that the bond is insufficient later down the road. You need to both claim your need for a bond and then offer evidence supporting what those damages would be as to your costs, such that the court can properly set the bond. In our business, if you don't ask for it, you don't get it. And in part, here, you didn't offer any proof on it. Since you didn't offer any proof on it, you don't get it either. Last case for this section is Equifax Services versus HITS. And to me, this is an interesting case. And part of it is it's an interesting piece of personal jurisdiction where they tell him, hey, you got to come out to the home office. And then they reprimand him. They have him out there. He returns to his sales territory in California. And then in part, where he worked solely in California, the company files suit at the head office in Kansas and uses, at least in part, his required attendance there as a basis for personal jurisdiction. Court doesn't care. The fact is that he does have some contacts, ties, and relations there. That is where he was paid from and all the rest. But I just think it's an interesting little twist on voluntary and purposeful activity within a jurisdiction when you're working for someone and they require you to come out there. And in fact, you come out there, but you also took checks there on a regular basis that helps to establish the personal jurisdiction as well. Now, with respect to the bond, and again, that's the theme for this grouping of cases. We've got an employee who, if he's out of work, he's going to suffer significant damages for a long period of time, as long as the injunction prevents him from working for someone else. The employer isn't likely going to suffer that type of monetary harm from wages, but they're arguing it's a loss of competition, a loss of their property and the like, and they paid, well, at least they had contracted for this period where the employee would no longer compete with them. But what happened here is when the defendant was enjoined, Equifax was required to only post a $10,000 bond under Rule 65C. And as Rule 65C says, that the bond is to secure damages in the event that the injunction is later determined to be wrongfully granted. But again, look at the language in Roman numeral 3. It says, at the hearing on the PI, defendant presented no evidence on the extent to which he would be harmed by an injunction. Therefore, we will not speculate that $10,000 is insufficient. Again, what we have to start to recognize is that the bond argument gives us another reason, in addition to the 5-part test, when we're making our arguments on a preliminary injunction, that we now can add to our arsenal in trying to defeat it, or at least to protect our clients against that injunction, is that the harm, when we talk about balancing those harms, that the harm to the party against whom the injunction is going to be granted is significant. And you then need to not just mouth the words that it's significant, but marshal the facts and the proof in order to show what significant means in dollar terms. If you don't ask for an injunction bond, you don't get it. If you don't ask that the bond be set at a high amount, you won't get it. If you don't offer proof, actual proof, not just words that spill out of the lawyer's mouth, but evidence that the record will receive as to how you will be harmed and how that amounts to dollars and cents, then in the event you put that proof forward, then you have a challenge if the court doesn't set the bond high enough. But here they set a $10,000 bond, even though the defendant presented no evidence on the extent to which he would be harmed by the injunction. Under the circumstances, as the court says, we're not going to speculate that $10,000 is insufficient. At that point, since you got some bond, you got $10,000, you got more than the last guy got. The fact is, you didn't offer any evidence. You might have given oral argument, but the fact is, what's the evidence? What were his wages? What would they be over a period of 6 months or a year? What is likely to occur to him from a financial standpoint in that period? You need to offer the evidence. It could be simply testimony by your client, but you got to offer it, and that's another reason why you need to think about, we need an evidentiary hearing. And if we're not going to get that, we at least need to present it by way of affidavit, so there is evidence in the record as to what that bond should be. Again, in our business, if you don't ask, you don't get. And as we've seen, both from the standpoint of the evidentiary hearing, that procedure that we focused on last week, and now on the bond as we're focusing on this week, there are procedural protections built into both the rules and the law in seeking and opposing injunctive relief. What we have to do as advocates is make sure that we insist on those rights to be followed and offer the evidence that the court needs or that we need to provide the court in order to be successful at the preliminary injunction stage. So they're good cases to me, and they sort of hopefully they slow down the process a little bit and expand your understanding of how that process works. That's it for the second class of Section 6.